Thank you for inviting me to be here as part of your Constitution Day observance. And truly, I'm especially delighted to be doing this here at St. Francis. I've had a couple of interactions with St. Francis, the administrators, the professors, and some of the students, and I'm really delighted to be here today. And I very much hope that we can increase the amount of interaction, cooperation between St. Francis and Brooklyn. We are, after all, just down the street. So it's Constitution Day. The day we set aside to think about the Constitution. And my talk today addresses the question exactly that. As Americans, how do we think about the Constitution? As Americans, how should we think about the Constitution? Now, when we think of the Constitution, several things often come immediately to mind. Most notably, we think of the end of June. The end of June, the time when the Supreme Court announces its rulings on the most important cases of the term, cases that are very often, in fact, usually constitutional law cases. Now, several things flow from realizing that one of the immediate things we think about when we think about the Constitution is what the Supreme Court says. First of all, it means that we think about the Constitution as a lawyer's document. In other words, we think about the Constitution as a source of law, and thus as a foundation for standard legal argumentation of the sort that we see in appellate briefs, in oral arguments, and ultimately in judicial opinions. Second, it means that we think of the Constitution as subject to judicial interpretation. After all, lawyers make their arguments to the judges, who then decide which side has the correct or at least the best interpretation. Third, and by extension, it means that when we think about how the rest of us relate to the Constitution, there's a great deal of ambivalence, a great deal of ambiguity. After all, if we're not lawyers and if we're not judges, then maybe we participate in the process of interpreting the Constitution only indirectly, through the arguments our lawyers make, through the opinions our judges write, and maybe even more indirectly through our influence on those arguments and opinions as either clients of the lawyers or members of the voting public whose preferences in turn influence who gets selected to be on the Supreme Court. Now, I don't know about you, but this to me seems to be a very impoverished way of thinking about how the American people relate to the Constitution. After all, the document does begin, quote, "We the people hereby ordain and establish this Constitution," unquote. To say that we participate in deciding what that document means only indirectly, almost by accident, seems unsatisfactory. But before we consider that idea more carefully, I want to offer a competing answer to the question, what do we think about when we think about the Constitution? In particular, I want to suggest that when we think about the Constitution, we think about something much more than the lawyerly meaning of the document, as I described a few minutes ago. Think, for example, about the First Amendment right to free speech. Not the details of the speech clause, but the basic fact that the First Amendment guarantees something called freedom of speech, whatever that term actually means. Now think about how often that term, the right to free speech, is used. Think about how often you've heard it used, even in situations that are not technically governed by the First Amendment. For example, private employers are not bound by the First Amendment. St. Francis College is not, Brooklyn Law School is not. Yet think about how employees often complain when a private employer tries to restrict an employee's speech. Think about internet service providers or providers of social media, for example, Facebook or Twitter. They're not subject to the First Amendment either. But when those services, but when users of those services are restricted in their use of Facebook, for example, when Facebook changes its terms of service, users will very often cite the First Amendment or the freedom of speech in challenging those decisions made by those private parties who are not technically subject to the First Amendment. Now, there's a detailed doctrinal point to be made here. Only governments are subject to the First Amendment. If you go to law school or if you take a constitutional law class, you learn to call this, quote, the state action requirement or the state action doctrine. But there's a larger, more general point that's important for current purposes. That larger point is that as Americans, we think of our constitutional rights as existing beyond their technical scope. We have the right to free speech, even when the entity restricting our speech is not technically subject to the First Amendment. We have the right to racial equality, even if the entity discriminating against us is not technically subject to the Equal Protection Clause, and so on. Now, one might say that this is simply a case of Americans getting their con law wrong. Basically, Americans misunderstanding the Constitution as applying to private parties in addition to applying to government actors. But that's a superficial conclusion that I think obscures a broader point, a more important point. Americans think about their constitutional rights in ways that go far beyond the details of conventional, technical, legal doctrine. When a Facebook user complains about her free speech rights being denied, or when an employee in a private company complains about racial discrimination, what they're doing is using the language of the Constitution as illustrative of the general concepts of rights persons in a free society should enjoy: racial equality and the right to free expression in these cases. In other words, they're using the Constitution's grant of rights not as source material for lawyers' arguments, but rather as the font for understanding what it means to be a citizen in a free society. Now, once we understand this, once we understand, in other words, that the Constitution is more than a technical, specialized document for the use only of lawyers and judges, then we need to think about how Americans can make maximum use of that document. There are ways that we can readily identify how we can use the document beyond a lawyer's use. First, as I noted earlier, Americans use the Constitution's grant of rights as reflecting our heritage of freedom more generally. Thus, for example, even though a Facebook user couldn't bring a First Amendment claim against Facebook, she can still, and we often do, cite, quote, the right to free speech, unquote, as an argument challenging a particular Facebook policy. Second, Americans use constitutional rhetoric in political argumentation more generally. When conservatives oppose federal regulation on the ground that it trenches on states' rights to govern themselves, they're making an argument based on the federal structure that our Constitution establishes, even if their particular argument wouldn't necessarily hold up in court. Take one example. The constitutionality of the Affordable Care Act was firmly established as a matter of constitutional law doctrine in 2012. But if a Republican wins the presidency in 2016 and calls for repealing that law on the grounds that regulating health care is not the proper business of the federal government, then the ensuing political debate will, at least in part, be about federalism, or, in other words, about our conception of constitutional law. This dynamic occurs at the other end of the political spectrum as well. For example, we often see calls for federal intervention to counteract oppressive acts by localities. For example, most notably over the last several years, we've seen this in calls that are made for the Justice Department, the federal Justice Department, to investigate a local police force that's been accused of racist policing practices. These calls for federal intervention have a history that date back to Reconstruction, where the federal government was seen as the protector of freed slaves against local white majorities intent on oppressing them. More to the point, these calls for federal intervention to ensure that states respect their citizens' equality and liberty rights map closely onto the entire idea of the 14th Amendment and its federal prohibition on state actions that deprive persons of equal protection or liberty without due process. Such political phenomena, what we might call constitutional/political phenomena, can engage even more closely with traditional constitutional doctrine. Consider, for example, the recent debate over so-called sanctuary cities, cities that have decided to not fully enforce federal immigration law. In 1992 and again in 1997, the Supreme Court decided cases that established a proposition that the federal government lacked the power to, quote, commandeer, unquote, state lawmaking or state law enforcement. In other words, Congress can make certain policy decisions and thereby displace state regulatory power. Congress can also send state law enforcement apparatus into the states to enforce that federal law. But the one thing Congress may not do is to force states themselves to make those regulatory choices and to force state law enforcement to enforce federal regulatory choices. Thus, when cities adopt a sanctuary cities policy and refuse to enforce some federal immigration law, they're responding directly to Supreme Court constitutional doctrine. Okay, so let's take stock so far. We've realized that the Constitution is viewed as much more than simply a lawyer's document. To be sure, it is a lawyer's document. Always has been, always will be. But it's much more than that. What else is it? Well, as we've seen, it's a source of rights that go far beyond the technical scope of those rights. Instead, the Constitution and the rights it provides have become deeply ingrained in Americans' minds as reflecting fundamental rights that inhere in the idea of free citizenship. For example, the right to freedom of speech. For example, the right to racial equality. In addition, as we've seen, the Constitution is a tool of political rhetoric, and indeed a tool for calls to direct political action. Repeal the Affordable Care Act, open an investigation into the Ferguson Police Department, or adopt a sanctuary city policy. Okay, the topic of my talk today is whether we can go even farther than these uses of the Constitution. In particular, I want to talk about whether we can find ways to unite the lawyerly understanding of the Constitution that I've talked about with the more political or popular understandings that I've also discussed. Today, I want to offer three possible ways of doing this. Now, this task is something I've thought about in my scholarship. I write about the 14th Amendment, and in particular the Equal Protection Clause, as a legal scholar and indeed as a lawyer. When I think about the 14th Amendment, I think about its lawyerly meaning. But in thinking about the 14th Amendment, and in particular about the Equal Protection Clause, I'm struck by the degree to which applying the majestic yet vague guarantees of the equal protection of the law or even due process of the law, to the extent to which those protections require a deep understanding of social reality. A fancy term for what we as Americans really think is required in order for us to fully be equal, in order for us truly to have liberty. Now, as it happens, the 14th Amendment provides us with a ready-made vehicle for allowing that deeper understanding of what equality requires to mesh with the Constitution as a lawyer's document. Section 5 of the 14th Amendment authorizes Congress to, quote, enforce, unquote, the other provisions of the amendment, for example, the Equal Protection Clause. What we have here, then, is a confluence of the lawyer's document version of the Constitution with its more popular understanding. The lawyer's document version recognizes a role for Congress in enforcing the most important rights we have today against state governments, the rights granted by the 14th Amendment. The popular understanding of the document reflects what Americans really think when we think about equality, what Americans really think when we think about liberty. If we can mesh these two concepts, the lawyer's document understanding and the more popular understanding, then we will have gone a long way toward reconnecting the Constitution with the people who are ultimately responsible for it. Unfortunately, the court's current, and there's always an unfortunately after very stirring words like that. Unfortunately, the court's current approach to the enforcement power leaves much to be desired, both as a matter of legal logic, but also, more importantly, as a matter of achieving the task that I've laid out just immediately previous. Today, when the court considers a claim that an enforcement statute exceeds Congress's power under the Enforcement Clause, the court asks whether that statute is, quote, congruent and proportional, unquote, to the 14th Amendment right it seeks to protect. The congruence and proportionality standard dates from 1997, and thus is relatively recent. It's also been criticized as being unfaithful to the original understanding of the scope of Congress's enforcement power. I don't want to engage those critiques today. Instead, what I want to do today is I want to think about the imperative that maybe drove the court rather, to embrace the congruence and proportionality test, and then think about how the court has applied that test in real-world cases. First, what drove the court to insist that enforcement legislation be congruent and proportional to the underlying constitutional right Congress is seeking to protect? I believe what led the court to adopt that test is tension. Tension between Congress's enforcement power, on the other hand, and the role of the federal courts, and the Supreme Court in particular, in ultimately stating constitutional meaning. The 14th Amendment rights Congress has the authority to enforce are very broad. Guarantees against deprivations of life, liberty, and property without due process, guarantees of the Bill of Rights, which have been incorporated to apply against the states via the 14th Amendment Due Process Clause, and finally, the Equal Protection Clause. Now, if Congress has the power to protect these very broad, vaguely stated rights without a meaningful check from the court, then Congress essentially has a blank check to determine what those rights mean. For example, if Congress determines that race-based affirmative action, or single-sex education, or confining marriage to opposite-sex couples reflects the meaning of the Equal Protection Clause, then presumably it can legislate to, quote, enforce, unquote, those rights. Just to be clear, I use these examples not to suggest that any of these potential understandings of equal protection are right or wrong, but simply to note how a broad enforcement power would allow Congress essentially to dictate the meaning of the 14th Amendment. I would suggest to you that it was that fear, the fear that Congress might assert for itself the power to interpret the Constitution, the power that the court has jealously guarded ever since Marbury versus Madison way back in 1803. It was that fear that led the court to insist that enforcement legislation have a connection with, i.e. that it be congruent and proportional to the underlying constitutional right. Excuse me. As such, the congruence and proportionality test has much to commend it, at least if one assumes that federal courts play a useful role in guarding constitutional rights. Now, to be sure, different scholars will disagree on whether the court has had a good record in protecting constitutional rights. The critics of that idea do in fact have a point. The court that we like to hail as our last best protector of rights was the same court that allowed the repression of left-wing speech throughout the 20th century. It was the same court that upheld the internment of Japanese Americans during World War II. It was the same court that upheld racial segregation until the 1950s and 60s. It was the same court that did not rule for a women's rights plaintiff until 1971. But just as the court's heroic side can be overemphasized, that rule can be underemphasized as well. It's true the court upheld segregation until the middle of the 20th century. But it's also true that the court reversed unfair convictions of black defendants in the South in the 1930s, most notably in the Scottsboro cases, well before the cause of racial justice had become popular. The court's concern for criminal defendants, hardly a popular group, only grew during the Warren Court of the 1960s. The offense to political forces from the Warren Court was so great that several of those justices on that court were subject to impeachment drives in Congress. The court may have given in to calls to suppress left-wing speech, but it also upheld the right of protesters to burn the American flag. Even the controversial Citizens United case reflects a court that has insisted on its own understanding of the freedom of speech in the face of bipartisan attempts to regulate campaign finance. So there may be something to the idea that the court should have a unique authoritative role in deciding what the Constitution means, and so therefore there may be something to the idea that Congress should not have an unchecked power to interpret the 14th Amendment under the guise of enforcing the 14th Amendment. But don't forget, Our task today is to figure out how we can give Congress some meaningful role in stating constitutional meaning. On the one hand, we want to ensure Congress isn't able to go too far, but on the other hand, we also want to make sure that Congress, and by extension you and I, have some role in determining what our Constitution means. This requires, then, to think about how the court has applied the congruence and proportionality test. And I'd like to think about this issue in the context of enforcement legislation that Congress has enacted in order to protect the equality rights of Americans. Now, in order to think about this issue, we need to get a little bit into the weeds of constitutional law doctrine. Most of the time, a plaintiff mounts an equal protection challenge to the law. The court gives pretty minimal scrutiny. The doctrine simply requires that the law have, quote, a rational connection to a legitimate government interest, unquote. This is not a major hurdle. As suggested by the adjectives rational and legitimate, the court's scrutiny is not particularly harsh. But particular types of classifications do get harsher scrutiny. Race classifications in particular are subject to what's called strict scrutiny. Strict scrutiny requires that the challenged law be, quote, narrowly tailored to achieve a compelling government interest, unquote. The adjectives in this case, narrowly tailored, narrowly and compelling, suggest much more careful judicial scrutiny. The classifications that get this more careful review are called, unsurprisingly, suspect classes, quote unquote. Now, the details of these levels of scrutiny are not so important. What's important is that they exist and the reasons they exist. Usually, the reason a court decides that a particular type of classification, a particular instance of discrimination doesn't get anything more than so-called rational basis review is that the court believes that the group in question is represented in the political process and can protect its interests there. As long as the court is comfortable that the group can use the political process to defend itself, the court's generally not willing to give careful scrutiny to laws that impose burdens on that group. Now, there's good reason for courts to tread lightly when considering equal protection claims. It's awfully hard to determine when a particular legislative classification, for example, to tax one set of taxpayers more lightly or heavily than another, reflects real differences between the groups, and by contrast, when that classification reflects something more nefarious. More generally, legislative line drawing is a pretty tricky business. Lines have to be drawn somewhere, and for courts to decide that a given line is unconstitutional, there has to be pretty strong evidence that it's truly arbitrary and not just a result of a need to draw a line somewhere. For example, in 1976, the court upheld a Massachusetts law that required state troopers to retire at age 50. Even though some state troopers, including the plaintiff in that case, were still in fine physical condition. The court suggested lines have to be drawn somewhere, and the fact that a given line isn't perfect doesn't mean that it's unconstitutional. Okay, fair enough. It's hard for courts to decide equal protection claims, and so they very often refrain from giving careful scrutiny to many legislative lines that might strike us as unfair, imperfect, or simply irrational. What does this have to do with the enforcement power? Well, I'll tell you. When the court applies the congruence and proportionality test we described earlier, it calibrates its review according to whether the law affects a non-suspect or a suspect class. In other words, enforcement statutes that enforce the equality of rights of suspect classes tend to be reviewed very deferentially. Congress has lots of leeway to legislate to protect the equality rights of suspect classes. Conversely, laws that seek to enforce the equality rights of non-suspect groups tend to be reviewed stringently. Why? Well, the answer the court gives is that discrimination affecting those latter non-suspect classes is usually not unconstitutional. Because that discrimination is usually not unconstitutional, Congress has less business using its enforcement power to protect them. Quite literally, laws that protect such non-suspect classes are not congruent and proportional to the equal protection right because those laws, according to the court, likely do not target conduct that the court would find to be unconstitutional. Sounds simple, right? But don't forget, the reason most classifications get deferential review in the first place is that courts are nervous about second-guessing legislative line drawing, legislative determinations about whether a given classification is fair or unfair, reasonable or arbitrary. In other words, when a court upholds a classification as not violating equal protection, it may not be saying that the law is constitutional as a matter of theory. Rather, it may simply be saying that the court is itself unable to reach a competent decision about that law's constitutionality. Given that lack of institutional competence, the court defers. But Congress is not similarly limited. Congress is not a court. Therefore, Congress has much more capability to judge whether a state law that classifies is in fact consistent with equal protection. If this analysis is true, then perhaps we should allow Congress much more leeway than the court has up to now to use its enforcement power. So far, so good. So far, we've established that Congress may have more competence than courts to make the decisions that are relevant to equal protection analysis. That would suggest that Congress, our representatives, and therefore ultimately we as Americans, should have more of a role in determining what the 14th Amendment requires in order to turn its vague, majestic phrases into living, concrete reality. But what does our call for increased congressional power do to the argument that the court, not Congress, should have the final power to decide what the Constitution means? Recall earlier that we provided reasons why the court's understanding of constitutional meaning should, in a real way, be authoritative. Maybe the court really ought to have the final say on what the Constitution means. How do we square that with this increased role for Congress? In calling for this greater congressional power, are we calling for Congress to have an unchecked power to interpret the 14th Amendment? I've thought about this question. It seems to me that we can, in fact, have our Constitution Day cake and eat it too. In particular, we can enjoy the benefits of judicial supremacy in stating constitutional meaning while also enjoying the benefits of a larger congressional role, and thus a larger role for us as American citizens in enforcing the 14th Amendment. How do we do that? First, we should recognize that at the end of the day, when Congress enforces the 14th Amendment, it should have to stay within the parameters set forth by the court when the court interprets that document. But second, we should also understand that much of the court's 14th Amendment case law does not actually state constitutional meaning. Instead, much of that case law reflects what we've talked about earlier, courts' caution in reviewing state laws that are challenged on equal protection grounds. As we said, oftentimes a court will uphold a challenged state law alleged to violate equal protection, not because the court thinks it's necessarily a constitutional law, but because the court doesn't have the analytical tools to make the decision competently. Does this mean that we should reject the argument that that enforcement legislation should be congruent and proportional to the rights Congress is seeking to protect? Not at all. What it does mean, though, is that we need to be careful when we think about what those rights really are, what the court has actually said about the 14th Amendment. In the context of the 14th Amendment, there is a deceptively simple answer to the question, what is the constitutional right Congress has the authority to protect? The answer is simply this: laws that are either irrational or based on animus. That is to say, laws that are based on a conclusion that a group is morally inferior. Now, it may sound strange to you, given the complexity of the court's equal protection jurisprudence, but all that complexity largely boils down to two core constitutional requirements. The laws cannot be irrational, and the laws cannot be based on animus. Those are the law of the Equal Protection Clause, and those are the rules to which congressional enforcement legislation should be congruent and proportional. Think about what this would mean for congressional debates about enforcement legislation. Finally, we could have debates that matter. We could have debates about enforcement legislation that focus on whether, in fact, the state laws in question really are irrational, or whether the state laws in question really do treat certain groups as morally inferior. That's the kind of debate that Congress ought to have when it debates enforcement legislation. That's the kind of analysis the court ought to do when it considers claims that enforcement legislation violates the 14th Amendment. Now, in the very short amount of time I have remaining, I'd like to talk about two other ways that we, the people, can enforce the legal meaning of the Constitution. I want to discuss two very disparate issues. Two issues that on their face have absolutely nothing to do with each other, except for the fact that courts decided them this year in 2015. In May of this year, the Second Circuit Court of Appeals decided that the USA Patriot Act did not authorize the bulk collection of telephone call metadata. That is to say, the data about which numbers were called, from which number, at what time of day, and for how long. You may recall that this case arose after Edward Snowden disclosed the NSA's program for collecting that metadata, not just from people they suspected of terrorist activities, but from every American making a phone call on the national network. As you might imagine, such a massive, highly controversial program triggered constitutional claims. In particular, it triggered claims that the program violated American speech rights under the First Amendment and rights to be free of search and seizure under the Fourth Amendment. And you can easily understand how those arguments came about. Speech rights are surely chilled when you know that the government is not listening in on the call so much, but they are in fact keeping notes on where you called from, how often you called, and how long the conversation went. Whether it's a rape crisis line or a phone sex line, your speech would be chilled if you knew that government was keeping tabs on who you called. The Fourth Amendment claim, again, very intuitive. Of course, it's a seizure of information about you. Where you called, when you called, how long you talked. You can understand how First and Fourth Amendment claims were brought. Now, that doesn't, just because these claims are intuitive doesn't mean that they should win. After all, we know what happened on 9/11. We don't want it to happen again. What we have here, therefore, is a basic conflict between liberty on the one hand and security on the other. A conflict that's lasted as long as American history. So big, difficult questions. Don't they call for big, complex, constitutionally based answers? Well, maybe not so much. What the Second Circuit did in the case was they decided the case not on the First or Fourth Amendment ground, but on a statutory ground, that the USA Patriot Act did not authorize that data collection. Now, what's the relevance of the court's choice to use the statute as the grounds for striking the program down rather than the Constitution? The relevance is we, the people, when we think about renewing the Patriot Act, get to have the debate about whether we really do want to authorize that collection. We, the people, get to make the call about the balance between liberty and security. To be sure, if we get the call wrong, then the court will step in and reach a constitutional question. But we get the first crack at the issue by deciding what we want to authorize under the Patriot Act. What a great approach, giving us the decision as the American people rather than immediately deciding it at the judicial level. This brings me finally to my last example, to my last instance of we and the Constitution and how we relate to it. Kind of the mirror image case from the Snowden case, the same-sex marriage case, Obergefell versus Hodgetts. As we all know, this past June, the court decided that bans on same-sex marriage violated the 14th Amendment. The dissenters in that case focused on one particular argument. They accused the majority of taking the debate away from the American people, from the legislatures, from the town halls and discussions that were happening politically, and deciding it once and for all the 50 states. That was the argument. Seems to be taking the Constitution away from us seems to be, sort of the opposite of what I'm arguing for today. Justice Kennedy, writing for the majority in the case, had an answer to this. What Justice Kennedy said was, well, actually there's been a lot of discussion of same-sex marriage. He said, quote, there's been extensive litigation, referenda, legislative debates, and grassroots campaigns, as well as countless studies, papers, books, and other popular and scholarly writings, unquote, on the issue. How much of that popular debate is enough before the court takes the issue away from the political debate? Well, Justice Kennedy had an interesting take on that question, and I'll close with this. In answering this question, Justice Kennedy said, not just there's been a debate, there's been enough of a debate, now it's time for the courts to decide. No, what he said was, quote, that political debate, quote, has led to an enhanced understanding of the issue, an understanding reflected in the arguments now presented for resolution as a matter of constitutional law in this case, unquote. In other words, we the people, through our quasi-constitutional political debate about same-sex marriage, informed the court's decision about same-sex marriage. Our debates, our referenda, our initiatives, all of that informed the legal issue that the court ultimately decided as a matter of the Constitution, as a lawyer's document. What we have to conclude is, again, the ultimate ongoing tension between judicially protected rights on the one hand and political debate on the other, which allows Americans to express their own understandings of the Constitution. These three examples, the enforcement power, the Patriot Act example, and the same-sex marriage example, are different ways in which we as Americans can relate to the Constitution, not just as a lawyer's document, but instead as a document that we have to think about every single day as we go about our lives as citizens in a free country. Thank you. Yes. So the Second Amendment, the right to keep and bear arms, was really the only amendment that was prefaced by a statement of its reasoning, right? A well-armed militia being necessary to the security of a free state, comma, the right to keep and bear arms shall not be infringed. So the framers of the Second Amendment clearly had a reason for why they put the amendment in. It was all about the militia. Now, there was a great debate in 2008 at the court about what that prefatory clause meant. The dissenters in the case said, oh, it's obvious. The Second Amendment is all about service in the militia. An individual right to keep and bear arms is not what's implicated by the Second Amendment. The majority said, well, no, not so fast. The majority said, maybe the reason for including the right had something to do, in the Bill of Rights, had something to do with the militia, but they included the right, and it's the right that we need to interpret today, and we interpret that right as an individual right. Even though the reasons might have been militia-based, the right itself is individual rights-based, or so the majority said. So I take the question as sort of addressing the difficulty of figuring out what this, popular political debate really consists of. Is it elites that are simply having the debate? Is it really the American people themselves who are having the debate? And of course, you're right to flag the issue. When we say, when legal scholars say, oh, the American people are having a constitutional debate about an issue, we may be kind of looking at a very narrow swath of American society that's thinking about that, right? On other issues, though, maybe not so much. And so I would invite you to recall, if you watched the debate last night on CNN, Rand Paul was talking, and the other former governors were talking about the 10th Amendment. So there is, in fact, constitutional discourse and this is all in relation to the question about medical marijuana and what the candidates would do. So there was constitutional discourse that was being done, not necessarily at just the elite level, but instead communicating that discourse to the voters in the Republican primary. And so, that's the kind of debate that I think that I'm thinking about when I think about political debate that can inform what the Constitution ought to be understood to mean. But it goes even beyond that. We don't have to explicitly cite the Constitution, right? So just one example that pops into my head. So when protesters say Black Lives Matter, in one very basic way, that is an equal protection grounded argument, right? That everyone's life ought to matter equally, including the lives of black persons, right? And so I think the Black Lives Matter campaign is really a quasi-constitutional one that's grounded in some notion of equality. They don't use the 14th Amendment per se, not, unlike Senator Rand Paul last night, who was talking about the 10th Amendment a lot. They're not citing chapter and verse of the Constitution, but they're using the same kind of argument. And that's the kind of argument that I think can really inform, or should inform, what we think our Constitution means, and then we can make it happen. We can make it concrete reality, for example, by passing legislation enforcing the 14th Amendment. Oh yes, absolutely. So, of course, Justice Scalia has a conniption. Anyone starts talking on the court about the evolving meaning of the Constitution, because he thinks that the Constitution has a meaning. It was the meaning that was enshrined in 1789 or in 1868 when the 14th Amendment was ratified, and that's it for all time. And so absolutely, when Justice Kennedy says, for example, figuring out what same-sex marriage means as an equality matter really requires that we understand our evolving sense of, what marriage is. That is something that, people like Justice Kennedy simply do not accept because their jurisprudential view is inconsistent with an evolving understanding. Absolutely, that's what a lot of the debate at the end of the day is all about in cases like Obergefell.
One last
Okay.
follow-up, and then we really must stop and go outside and have some cake.
I think another place where that applies equally strongly is when you deal with cruel and
Oh yes,
punishment.
yes, absolutely. So yeah, so just to sort of to amplify, the Eighth Amendment prohibits cruel and unusual punishment. In an important case from 1958, the court says, what does that mean? Well, it's defined in part by the evolving standards that mark a maturing society. Evolving standards, what we think is cruel, that governs the Eighth Amendment, not what was cruel and unusual in 1789. Because what was cruel and unusual in 1789 is probably not very much. And a lot of stuff that we think is really awfully cruel and pretty unusual would have been standard fare way back in 1789. And again, Justice Scalia would say, have at it.
Thank you
Thank you so much.